can I start by saying once again that the circumstances which the claimant describes suffering as a result of the infection he has can only evoke the very deepest sympathy, and the witness statement obviously makes for painful reading, and we all sense that and sympathise greatly with it. That notwithstanding, this case needs to be determined according to the application of legal principle. I'm going to make just a few very quick preliminary points. The first is that it's not accepted by the defendant that the claimant was infected with NHS blood. That's just not, there hasn't been any forum for that issue to be resolved yet. In the case of hepatitis C, an application would be made to a panel who would decide on a balance of probabilities whether or not hepatitis C had been received from NHS blood, and that has not yet happened in this. Sorry, not yet happened. There hasn't been an opportunity.
You're going to have to speak up a bit, Mr. Tankle. You drop your voice halfway through the sentence.
There hasn't been an opportunity for that to happen in this case.
Well, presumably because it's part of the inquiries that are made either by the panel.
Precisely. And the second very quick point I wish to make is I do take points on delay and on the manner in which this case has reached a court of appeal, but you've heard half a day of argument on the merits this morning, and so I will deal with those first and then get on to those other points at the end.
Yeah, well, you complain about the fact that they appear to have got permission on the basis of an argument about whether or not there was screening in the 1970s, which is now completely abandoned.
Yes, and more to the point, is something they ought always to have known when they made that application back in July 2021.
So what ought they always to have known?
I'm sorry?
What ought they always to have known?
That screening for hepatitis B was introduced in 1972, and that was never the subject of any real doubt. I'm sorry to say, but in more recent inter-parties correspondence, there is even a suggestion that they did know in July 2021 that this matter was not the subject of any realistic doubt. I'll come on to that at the end.
Okay. So you're going to deal with substance first?
Yes. I'm going to make some general points about this scheme and then analyse it by reference to each of the limbs of the proportionality test, hopefully more quickly. Because, of course, all of these various limbs of the proportionality test overlap and interact. Now, in general, there is a system in this country of fault-based liability. Different countries have other systems, but that's the system in this country, including for claims of clinical negligence. It's possible to depart from that system to varying degrees, but departures from that system have a number of costs associated with them. So, for example, they tend to be much more expensive, and that is a strain on the public purse. Secondly, they can impact on the doctor-patient relationship. If every doctor knows that there's a possibility of an ex gratia non-fault claim to be made, that might result in more conservative treatment, or it might involve in more liberal treatment. We don't know, but there could be impacts. And thirdly, the existence of a successful negligence claim tends to result in an opportunity for lessons to be learned from poor practice, and that goes when one has a no-fault compensation scheme. But it's important to emphasise that the default position, the background position, is that there is that system, and there needs to be a reason to depart from that system. Now, the way that the appellant's case is almost put the other way. There's an ex gratia system, and you need to justify my not being included in it. But in fact, what that ignores is the pre-existing context of the fault-based system of liability. Now, in the case of hepatitis C, it was recognized in around 2002 or 2003 that there were a large number of people claiming to have been infected with hepatitis C from NHS blood. It was recognized that there was a moral and possibly also a legal claim on the state. And there were whether or not there was a legal claim, there was a very large number of potential instances of litigation that would need to be dealt with, which, whether or not successful, would clog up the courts and be very expensive to defend. Now, at that time, in 2002, and all of those were regarded as being reasons, ultimately, to depart from the fault-based system of liability, that there was always a balance to be struck between the benefits of a fault-based system of liability and the costs of establishing an ex gratia scheme. And things like the cutoff date, which I'll come on to in more detail later, reflect the balance that was struck at that time. Now, the same was not the case for hepatitis B. There weren't the same pressures, numbers, and the same sort of moral claim was not recognised. And that is because, well, I want to be clear, the appellant says the Secretary of State never applied his mind to any of this. Now, we're only at the permission stage, and we haven't gone back to the documents in 2002 and 2003 to see the level of thinking about hepatitis B. Certainly there was an awareness that there was hepatitis B, that there were people who suffered from it, but as to the extent to which sustained consideration was given to the position, I can't comment at the moment. So when I make these submissions, I need to be careful to explain that I'm explaining why one system was set up, but set up in the way that it was, not why another group of people was not included in that system. But at any rate, the same moral claim by those infected with hepatitis B was not recognised at that time. And the really key historical reason for that is because screening had been introduced in 1972. And that had a number of substantial consequences. The most obvious is that there were far fewer numbers infected. Now, the numbers that the court has available to it are the 25 versus the 20,000. The appellant is right to say that 25 is a provisional figure. The way that number is calculated is that thousands of witness statements have been submitted to the infected blood inquiry. There's a team of people working their way through them. When this claim first started, the question was asked how many of these are HBV, hepatitis B victims, and a count was done at that time. It was over a year ago now. And there were still thousands of witness statements left to count. We don't have an update on that figure. They're the only figures that the court has available to it. I agree that there may well be more. I don't know how many more. But I hope it's common ground that the introduction of screening worked to a significant extent and that the known numbers are substantially smaller.
Well, I mean, there's a very big disparity between saying that it worked to only 40 and 50% at the beginning and then rising to 80%, and those figures. Because if it only worked to 40 or 50%, and it's equally prevalent previously to C, then one would have expected there to be much larger numbers going through the net.
Yes.
So it doesn't quite work out, these figures, do they?
No, there may be other reasons for that. So, for example, it may be that hepatitis B is naturally less prevalent in the population. I don't know. But presumably all of this is material which will come out in due course in the infected blood inquiry, which is looking at all of this.
Well, it's been going on for a long time,
Yes.
and it's going to go on for a long more time. I mean, okay, anyway, keep going.
No, well, even so, and even with all of those necessary caveats in place, the discrepancy between 25 known cases and 20,000 known cases is very substantial, and a lot of it's hard to see in my submission how that gap can be entirely closed and explained simply by differences in quality of screening.
Well, natural clearers.
Natural clearance. Natural clearance. Well, we've
That was a question, not a statement.
and it may also be, we've deliberately not put our case on the basis of possible differences between hepatitis B and hepatitis C. I think I can say we don't accept the submission that they're the same. Our sense, based on, I can't say findings or whatever, but our impression, based on what we've heard at the inquiry, is that hepatitis B sometimes at least manifests itself less seriously, not in this claimant's case, but in the case of others. You've also heard that there are natural clearers, which is not the case, or not the case as much with hepatitis C, but we haven't put our case on the basis of differences between the two diseases. We're at the permission stage. It may need to be the subject of expert evidence in due course if permission is granted. For the time being, we are putting our case only on the basis of the introduction of screening and associated matters, but we don't accept the submission that hepatitis is hepatitis and they're all the same and that's the end of it.
Well, hepatitis C, according to this document I've been looking at, is an RNA virus, which hepatitis B is not. That makes a difference.
I have no medical expertise or knowledge, and I don't know.
No barristers have, but they speak a lot about these things when they're briefed.
Well, I'm not going to follow that pattern. Safe to say that there are levels and levels of distinctions between these things, and I don't realistically expect this court to say, well, we'll just wait till the outcome of the inquiry. And though we put our case...
Well, there is a difficulty if it's a discriminatory scheme.
Yes. Well, the appellant today has sought to narrow the gap between hepatitis B and hepatitis C. He's raised a number of new arguments in so doing.
Well, they may be new or they may be old, but the truth of the matter is that the two things that have cut some headway with me is that the scheme makes no mention of the screening.
Yes.
And that screening seems to be just one aspect of precaution that has been taken, which is not very clear, doesn't really allow for a very clear distinction. So that if that's right, then we're really on to justification. And that's your last resort, really.
Well, the point about it's right that the scheme does not itself refer to screening. The scheme refers to the cutoff date of September 1991, and that date is...
Where? I haven't seen that.
So you don't have... No, it's in the... it's not in the extract that you
No,
have.
but not the statutory scheme.
It's not a statutory scheme. It's in the memorandum of understanding.
It is a statutory scheme because we've been shown the directions and the regulations in the authorities bundle.
Well, can I take you to those directions in that case?
Yeah.
Because we started off with the directions at page 11.
Yes.
And then the memorandum, I understood, was a memorandum.
There is no provision in primary or secondary legislation which says there shall be a scheme. What you have at Authorities Bundle 11, page 11,
Divided 3. Yeah.
divided 3.
In the exercise of his powers conferred under the National...
So these are ministerial powers and the exercise.
Precisely.
Yeah.
So if one looks back at section, it's made really under section 7 of the NHS Act, which is Authorities Bundle 5 tab.
Well, those are the sections that give the minister his powers.
Yes.
Precisely. And they say that the minister can transfer those any of his functions to a special health authority, which is a
Right,
type
I
of
don't see that
statutory
Section 7 gives the Minister powers. Section 7 says the Secretary of State may direct
body. Yes,
a special health authority to exercise any function
Yes.
of the Secretary of State.
yes. It gives,
All that's a delegatory power.
yes, it gives him a delegatory power.
But that's not an originating power.
No, there is none in statute.
He has the royal prerogative powers.
Yes, it is an ex gratia scheme. The Secretary of State has decided to set up an ex gratia scheme because of the moral claim that victims of hepatitis C and HIV have on the state. He has then transferred the function of administering that scheme pursuant to Section 7 to the Special Health Authority known as the NHS Business Services Authority, and those are the directions at Authorities Bundle 11. And these are really party directions almost. They're the Secretary of State telling that Special Health Authority what to do. They don't create any enforceable right on the part of an individual citizen. And that's the very short direction, evident from paragraph 2 of these directions. The Secretary of State directs NHS Business Services Authority to act as administrator of the infected blood payment scheme. And that's all it's doing. It doesn't tell you what the infected blood payment scheme is. What it is an ex gratia compensation scheme with no source in primary or secondary legislation.
So your submission is that it's a prerogative power to set up the scheme?
Yes.
Yeah.
Yes. And it was really a response to Master of the Rolls' point. This is a legislative scheme. It's absolutely not. It's an ex gratia scheme with no statutory footing. But some legislative mechanisms are used to direct people to make the scheme work, but the scheme itself is not on a statutory footing. So,
So you say that the whole foundation of Mr. Howell's submissions is false, really?
it's most relevant to his point about ambit in Article 1 of Protocol 1. Because I accept that he might have a rationality argument, common law argument, saying like cases should be treated alike.
But it overlaps with your issues on justification, because if it is an ex gratia scheme, then of course it's within the minister's powers to devise the limits of that scheme.
Yes.
And although you might have thought that it would be very good to include people like the claimant, it's not unlawful not to.
Yes, and the fact that it is an ex gratia scheme, I will say in due course, is relevant to the width, the breadth of discretion the Secretary of State has. I think is the point my Lord was.
Well, it goes, you say, to the standard of review.
Yes. Now, I was being asked, where do we find the cut-off date? And the answer is not in any statute, because it's not a statutory scheme, but we do find it in the Memorandum of Understanding. Unfortunately, you've only got an extract from that document, which doesn't include the cut-off date, but it is there, and we can provide it to the court immediately after the hearing. And the cut-off date is obviously not an accident. It's a specific date, and it is the date which is universally accepted as being a date for introduction of hepatitis C. and again,
Screening.
screening, and the documents which surround the introduction of that test make it clear that this was about screening. But again, none of those are before the court because this isn't a challenge to the cutoff date. But the screening does the scheme does draw that boundary around the introduction of screening for hepatitis C. I'll come on to Chalice and explain why you don't have to follow what Mr. Justice Mostyn did.
Well, we obviously don't have to follow what Mr. Justice Mostyn does, but we do have to have an eye to consistency.
Yes.
Yeah. Okay. Well, good.
Now, my Lord the Master Rolls raised a second point. He was addressing the first one about the date and where we find that. I think my Lord's second point was about the screening being just one part of a
screening is not a very particularly binary exercise because
no.
it's just an aspect of precautions taken.
Yes, I mean I'm afraid it's this morning was the first time I've heard that submission made, and I'm not in a position to respond to it because there's an incredibly long history here, and I'm just not, unfortunately, in a position to respond to it. It certainly wasn't a point made.
Well, I mean, you don't contest the percentages, do you? Of
Again,
the effectiveness of screening, you don't.
I'm again caught off guard.
Those percentages are in the bundle, though, so you're aware of them.
Yes, percentages from the 1980s. I think the point we make about these percentages is I mean they're in the bundle, yes, but all of these things are a subject of controversy, with points being made on both sides as part of the infected blood inquiry, which is why I'm being hesitant to say we either do or don't accept particular figures which were given by certain people however many years ago. Again, this is all information, material which will come out in the wash as part of the inquiry and the findings that are made.
Well, I mean, it may do.
Yes.
But we have to deal with this application
Yes.
on legal principle.
Yes.
Yeah.
And all this court knows is the 25 versus 20,000 figure.
Well, I mean, just leaving the 25 versus the 20,000, it is perfectly clear, isn't it, that screening is not totally effective.
Yes. Yeah. It's not for hepatitis C either.
No.
But that's never been regarded as being a reason to extend the system out more wide, the scheme out more widely, because no medical procedure is fully safe. At the end of the day, blood transfusion or the receipt of a blood product is a medical procedure. It's a particularly common type of medical procedure that happens tens of thousands, if not hundreds of thousands of times each day up and down the country. There are many common medical procedures which carry known complications. Infection is one, allergic reaction, anaphylactic shock is another. There's vaccine injury. There are problems associated with vaginal mesh. There are all sorts of known complications. There are complications which arise from surgical procedures, and the system which we have for sorting all of that out is the process of informed consent and a fault-based system of liability. Now, the claimant in his witness statement, and the reference is supplementary bundle, page 23, paragraph 18. I think it's page 25 of the PDF.
Sorry, paragraph number?
It's paragraph 18 of the claimant's witness statement, so page 23, the supplementary bundle, is unable to say whether he's ever been treated without his consent. But he says, I do not know if I've ever been treated without my consent. But that's the system that we have. So what we have in essence is an individual saying, I may or may not have given my informed consent. I can't positively aver that I didn't. I suffered a known complication, and therefore I should receive compensation. But the system can't work that way, because if it did, it would collapse under the weight of the pressure of the costs associated.
It all goes back to the Pearson report in 73 and 79, doesn't it?
Yes.
The no-fault system that was proposed and then not taken up, partly because of the New Zealand experience.
Correct. And when it was, when these schemes were being set up in 2003, 2004, between Pearson and these schemes, a number of different ex gratia schemes had been set up. So HIV, for example, or VCJD. And it's really done in a very patchwork way, responding each time to what's perceived by politicians to be a moral claim on society. And HCV was one example of that. And there was consideration given to the influence of the Pearson report and the fact that there are sort of holes punched in it by each of these ex gratia schemes. But at all times, a balance being struck between moving towards a ex gratia system of liability or maintaining a fault-based system of liability. And the Secretary of State's judgment as to where that balance needs to be struck is one to which the court must inevitably give a wide margin of discretion, especially in the context of ex gratia schemes, which the Secretary of State's got no legal obligation to establish. That there is no real yardstick by which the court can judge the Secretary of State's assessment as to what are more or less deserving claims. So the claimant says, I'm similar to someone who was infected with hepatitis C because it's a similar virus, it manifests in a similar way, it's had a similar impact on my life. But there are many, as I said, there are many known complications of common medical procedures, some more serious, some less serious. It's absolutely an invidious task to work out which are more serious, which are more deserving. And the Secretary of State essentially decides on a case-by-case basis, as these issues arise, what to set up schemes for. And there's a real problem if by setting up a scheme, he thereby invites claimants to come along and say, well, I'm similar or more similar or less similar to this scheme, and therefore the scheme should be extended to me. And this claimant could never, if there were no scheme, the appellant could never have come along to court and said, I need to be given an ex gratia payment, because there's no freestanding obligation to set up a scheme for victims of hepatitis B. The only reason he's able to bring this claim is because there is a scheme which exists for hepatitis C.
Well, that's the reason I was so impressed before your submission by Mr. Howell's submission that there was a statutory right.
Right, I see.
Had there been a statutory right, and we'll hear Mr. Howell's in response, but if he was right that there was a statutory right to this scheme, then anyway, speaking only for myself, that seems to place a different emphasis on the whole argument. If you're right that it really is an ex gratia scheme, that really is in the discretion of the minister, and that really is something that the minister has to decide as a matter of judgment, dealing with current situations as they arise, then I see your point.
I understand, and yes, well, I certainly make that.
You say there is absolutely nothing in that legislation. I haven't read every inch of it, but there is nothing in the legislation that it defines the scheme, but it defines the scheme as something that the Secretary of State has decided by his prerogative powers to introduce.
Yes.
I mean, it doesn't say that,
No.
but that might be in the explanatory
No, but
note.
that's precisely how I would describe it too. The high point of Mr. Howell's submission are those directions, which are functional directions, essentially delegating the Secretary of State's prerogative powers to administer a scheme to the special health authority known as the NHS Business Services Authority.
But you would accept this qualification, wouldn't you? Which is that if the minister exercises any powers, they have to conform with the common law restrictions on that. So they have to be exercised fairly and rationally.
Yes.
And similarly, a minister exercising powers can't unlawfully discriminate.
Yes.
Yeah.
Yes. It's not. It's certainly not free. It doesn't become a free for all.
No. You did hint at a suggestion that it wasn't justiciable, but I think that was just loose use of language.
I think it was a submission that the court doesn't really have a yardstick.
Well, that can be mistaken for saying it's not justiciable, and it is.
I understand. I'm not making the submission that it's not justiciable.
But I don't understand the point that if you accept what my Lord says, that the Secretary of State must not discriminate in exercising his powers to make an ex gratia scheme, I don't understand why he can't, if you're right. Because, in fact, by the very nature of the exercise of those powers, he is discriminating. I mean, unless he was going to allow anybody who's ever been injured by blood transfusions to claim, he is discriminating. I mean, we may have arguments about whether discrimination, whether as to status and as to relevant similarity, or relative similarity. But what you're saying is he can, and indeed must, discriminate, otherwise he couldn't afford it.
Well, he must discriminate, but he has to do it subject to the common law restrictions of doing so rationally and.
He can't unlawfully discriminate. He must only discriminate if there is a justification which the court respects.
Of course, and even if this scheme were to extend to hepatitis B victims, and the appellant was successful at the end of the day, then no doubt there will be another group coming along to court saying, well, I can now compare myself to this newly expanded scheme because it's no longer a scheme which is delimited by screening. So, I mean...
Well, depending on how evidence and so on came out, but it might be that it was limited by virtue of the fact it relates to hepatitis, that this, if was that what we were being told about hepatitis has legs.
Yes.
I think it's
yes.
I mean, the idea that to frighten us by saying, everyone was going to become pouring in with whatever to say, pick me too, is probably stretching it a little, don't you think?
Well, it is an important part of our submission that there is a need to draw a bright line. And the line needs to be drawn somewhere. The flip side of that line needing to be drawn somewhere submission is, otherwise there's no natural boundary. And you can see how that could be interpreted as an inter rorem sort of argument, a floodgate sort of argument. And in a sense it is, but I mean, it really is just the flip side of the need to have a bright line. And there will always be people who can say, I'm more or less similar. It doesn't take wild leaps of the imagination to identify, for example, hospital-acquired infection. It's an infection, it didn't come through blood, it came via some other route. But why should that not be subject to an ex gratia system of compensation? But it's recognised in the cases, in particular in RJM, that sometimes bright lines work harshly, but provided that they follow a rational boundary, that's just part of drawing a bright line.
Well, what if this is not a bright line?
I mean, it is a bright line around screening, and I hear the submission that's been made that screening is only one of a number of different measures on its porous. But I tried to answer that earlier in saying it's never been a part of the Secretary of State's logic that the screening system is infallible. It's just that the normative system for dealing with that level of risk is the system of informed consent and the fault-based system of liability. But once the Secretary of State, the NHS has done everything that it considers it reasonably can to protect its patients, then the rest is left to informed consent and the fault-based system of liability to clinical negligence claims. And if there are some people who aren't able to pursue a negligence claim, well, that's just the balance that the Secretary of State on behalf of society has decided to strike.
Can I just ask one question about the negligence claim? Do we know what the group litigation that this claimant was for a short period a party to with Derby solicitors or not?
I don't know.
No, okay, that's fine.
It may be that Mr. Howells knows. He had legal aid, which was withdrawn, and then he decided to withdraw his case. This was in the mid-1990s. And I would say that is just, it may appear harsh, but it's just the system playing itself through. So in the mid-1990s, he had a claim. He could have challenged the decision to remove legal aid. I don't know whether he did or not, but those are the sorts of processes which exist. But instead, 25 years later, we have a claim saying, well, there's a scheme for hepatitis C. I'm comparing myself to those. I'm similar in these ways. The Secretary of State says we were different in others, but he says, I'm so similar that it's irrational for me to be excluded. And we say, well, we've got to draw a bright line, and that's got to draw the line somewhere. That's really what the case is about. And ultimately, our defence is that the bright line's been drawn at a rational boundary, i.e. the introduction of screening. Yes, screening is not a clear boundary because some fall through the net, but we have always known that some fall through the net, and nevertheless, we have said that, well, bring a claim and it either will succeed or it won't succeed, but we can't keep extending this ex gratia system forever.
So the question really comes down to whether that is an appropriate objective justification, and that comes down to the intensity of review question. So really it all comes down to the sliding scale that Lord Newberger was talking about, doesn't it?
Well, on the intensity of review, I make these points. First of all, this is an area of social and economic policy.
Well, that's the first point, and the other point is that it's dealing with a disability, which it is.
Well, I've got a few other points on my side of the scales, and then get on to the other side of the scale. So, social and economic policy, ex gratia. So it's one might have thought that is even more. The Secretary has an even more of a free hand, not a completely free hand, but even more of a free hand because it's not something that he's bound to do by legislation. And third, the fact that it is responding to what's perceived to be a moral claim, which is I don't say injusticiable, but I do say.
But I think at the beginning of your submissions, I mean, it slipped into probably just a shorthand of you referring to it as a moral claim, but at the beginning of your submissions, I think you were quite clear that it was partly a moral claim and partly a recognition of the immense cost, time and resource implications of probably thousands and thousands of claims. So I think there's a fiscal, it's not just moral, it's a fiscal imperative. And I
also fiscal imperative. I accept that. I am slipping into shorthand.
Just as long as I'm clear that what your baseline is, that it is moral and fiscal.
Moral and fiscal. But there is certainly a strong moral element.
Understood.
Now, on the disability side, and this now feeds into questions of status. And while we don't contest that the claimant has a status, at least at the permission stage, we take a different view as to what that status is. Now, on analysis, really, the reason the claimant is not eligible for the scheme is not because he has hepatitis B. It's because he doesn't have hepatitis C or indeed HIV.
The judge said that was two sides of the same coin.
She did, and I'm not sure that. I mean, the way to test it is that any member of the general population applying, even someone without hepatitis B, would not be eligible for this scheme. It's not two sides of the same coin. But in the summary grounds,
it is in the hepatitis world.
well, and the question of status is often what level of generality does one look at it?
That's why it seems to me, again speaking only for myself, that the question of status here is quite irrelevant, really. I mean, anyway, at the permission stage,
Yes.
he probably has status. He probably is in a relevantly, or arguably in a relevantly similar position. The question is only whether your arguments just adumbrated are correct. Namely, that there is an objective justification. It's completely impossible. It's an impossible position if there is not an objective justification, etc., what
Yes.
you say. And there's no statutory scheme, so it's ex gratia, so that all pushes it back to, away from an intense standard of review, back to quite a free hand for the Secretary of State.
Yes.
And that's what this case is about, ultimately.
Yes.
I mean, is there any more authority than we've been shown?
I don't think I'm planning to take you to any.
Not for a permission stage, anyway.
But I mean, the intensity of review does take account of disability as a suspect ground. I think one can draw fine technical distinctions, talk about two sides of a coin. The example the appellant took you to was a case in which discrimination on the grounds of HIV was regarded as discrimination on grounds of disability and a suspect ground. And one can quite readily see why saying, for example, someone with HIV can't rent a house or whatever is suspect. This is different because it's even if one is looking at it only through the lens of the hepatitis world, it's just the difference between hepatitis B and hepatitis C. It's not the fact that the appellant has hepatitis B. My brain probably doesn't work as well as it ought, but I keep coming back to, in my own analysis, to the point that he is not being discriminated on the grounds that he has hepatitis B. It's just that he's not eligible for the scheme because he doesn't have hepatitis C, just as any other member of the general population. Or if one wants to lean more in that direction, more in the appellant's favour, as I try to do in the summary grounds, and one might say he has a claim as someone who gave informed consent to a medical procedure with a known complication which materialised.
I mean, the problem with that is that it's not really addressing the issue. I mean, we're at the position stage, and we reach stage 4, the question of objective justification, and your answer to the objective justification is he's not being discriminated against. Well, that's not an answer to the objective justification, which starts from the premise that he is being discriminated against. And to my brain, it's far more logical for you to say he is being discriminated against because we have to draw the line somewhere, because it's all about fault-based liability and consent forms, and therefore we cannot pay everybody. It's an ex gratia scheme, it's not a statutory right, and the intensity of the review is very liberal because it is something about giving people money they're not entitled to. And therefore, looking at Lord Newberger's judgment, the sliding scale is very much to the, I'm not sure if it would be left or right, and perhaps I shouldn't even suggest it, but it's very much to one side.
Yes, well, my lord, if I am content with that summary of the Secretary of State's case for the purposes of the commission stage.
And what I find with all these cases is probably because I'm a commercial lawyer, but what is that it's also it's like a game of whack-a-mole. You know, you sort of think you've got your handle on point 1, and then point 2 pops up, and then you deal with point 2, and they say, well, the answer to point 2 is point 1, and then you say, oh, no, it's really point 4. And I mean, it's all completely, to me, very imprecise, touchy-feely, if I could put it that way. But anyway, that's the way it is. I think I'm afraid I've reached the stage where I know that.
My lord, can I just see if there's anything else I need to pick up on ground 1 before I...
What do you call ground 1?
Well... can I just address you briefly on the question of ambit?
Why?
Why?
I mean, you accept that potentially there is, that he can establish that.
No, I accepted that he can potentially establish status.
Oh, right. Okay. Oh, you mean ambit being relative similarity?
No, I mean ambit being, is this really engaging a
Article
convention
8.
right at all?
Oh, Article 8. Oh,
You
Yeah,
get
so it's really square one. Do we
gosh,
we
yes.
to get off the starting blocks.
Back
do
to
we
that.
get off the starting block?
Okay. Ambit, yes. Yes, he was big on ambit.
So you can't get near Article 14 unless you've got your ambit for Article
Exactly.
8,
Exactly.
Or A1P1.
Or
Okay.
A1.
which is more commercial.
Not much, funnily enough. But do you contest that he has no ambit on either ground?
Yes.
Right, because?
Sorry, are you really saying none on Article 8 either?
Yes.
Okay.
I mean, first of all, the appellant appear that the scheme does make, well, so this way, the appellant has plainly suffered as a result of his hepatitis B infection. It's another thing, and that might affect his Article 8 rights, it might not, it's a different case. But what he says is, my Article 8 rights are infringed or within the ambit of Article 8 rights because I haven't received a compensation payment. And already the receipt of payment, quite a lot of stages further away from private and family life than for example, splitting up a family or immigration.
Well, the scheme is to help the family, right?
So I certainly accept that as an objective description of the scheme, it also makes payments to family members. It makes a one-off payment to eligible spouses, and then it makes discretionary means-tested payments to dependent beneficiaries. As far as we're aware, the appellant has neither. First point. Mr. Howes will correct me if I'm wrong, but that's what I pick up from his witness statement. He separated from his wife and they never had children. So on the facts of his case, it seems to be an arid academic point. The cases to which you were referred, I think, were JCWI, which is about parental leave, and SC, which is about the two-child rule. And both of those are about payment, but they're payment which plainly is connected to, in a very close way, to to family life. Whereas this appellant is saying, well, I'm not sure what he's saying in respect to family life, because as far as we're aware, he doesn't have a family.
But Article 8 is not so narrow as to be only
It's not
a family. It's also your personal and private life. And he says that his personal and private life has been very much affected by the fact he's without means to have a proper life.
Yes, by his illness, but
Well, and obviously by not having this payment that others like him have got.
well, others unlike him. Yes.
Well, others, I mean, like him in the colloquial sense.
Ambit is never really the most fertile territory on a permission application. But
Well, I will move.
that's not to stop you.
Well, look,
You've flagged up.
I've flagged it up. There's written submissions in my scaling argument.
Yeah.
I don't resolve from those. I take the point that my lord's just made, and I'll move on. Yeah. Okay. Can I move on in that case to rationality, the common law grounds, which I'll deal as briefly as my learned friend did.
Before you do that,
Yes.
you said that you wanted to deal with chalice. You could
I
deal with
did.
that afterwards or before rationality. It's just that rationality seemed to come at the end, perhaps.
Well, I'm happy to deal with. I've got a simple point about chalice, which I think has already been made a number of times. It's right to say that the claim in chalice, the rationality claim in chalice, is articulated in the statement of facts and grounds as a broad-based rationality.
Paragraph 27 and 28.
In the summary grounds of defence and reply, I think it's also right to say that the focus of the argument became more concentrated on the blurring issue. So the fact that you could possibly receive blood after September 1991 that had been donated before September 1991, subject to controversy. It may or may not be right, but that's what chalice. That's what the emphasis in chalice became about, and was the reason. The blurring issue is the reason that Mr. Justice Mostyn granted permission in that case. Now, it's not being suggested in chalice by the Secretary of State that the claimant is therefore limited to how he puts his rationality, how she puts her rationality claim. She's got her permission, and she'll develop her rationality claim as she wishes. But it's still relevant, in particular in terms of judicial consistency. For example, that Mr. Justice Mostyn limited his reasons in the manner that he did.
Do we have his reasons in
Yes.
I thought
think
I
they're-
thought I'd read them, but can you remind me where they are?
Page 113, I think.
In the authorities.
Supplementary bundles.
There's paragraph 1.
Why was that transferred to Cardiff, by the way?
I think that the
Was it the English infected blood scheme?
no, it was because of the proposal that it be linked with this claim, I think, which has now been transferred the other way.
The Cardiff Administrative Court office is in charge of the Bristol Administrative Court, and Chalice is in the Bristol Administrative Court.
Right. But it does concern the English infected blood product scheme.
Well, it is.
Yeah,
And it's now being heard in before the permission hearings before Mr. Justice J next Friday in this court.
Mr. Justice
J.
J.
So this is the renewed grounds, is that?
Yes.
Yeah.
Yeah. And it's a part heard hearing. In December, it all relates to ministerial submission, but because the renewed grounds pick up potentially decisions that were made back in 2003 around why was the date for the scheme chosen?
That was ground one.
That's ground one, and it was, rather than go and try and dig through documents that are thousands of documents 20 years old, the minister was invited to take a new decision as to whether to maintain the scheme on the basis of reasons as at today. That's what's happened, and that's why this ministerial submission has come into existence.
So almost as if permission was granted, minister was told to think again, and the minister did and came to the same decision.
Well, yes, except permission has not.
No, I appreciate it. Formally, it wasn't granted.
Yes, yes, but it's a similar process. So, yes, chalice was permission was granted on that ground, and that's certainly been the focus of most of the submissions. And as far as I'm instructed in chalice as well, and that's how the arguments seem to be developing. Although I accept that, as articulated in the statement of facts and grounds of rationality, challenge is not limited in that way. I think that's all I can really say about chalice. Now, irrationality, common law irrationality, as pleaded or as appearing on the face of the skeleton argument, is all about a case of Johnson from last year, and
I thought Johnson was 2016.
different Johnson, I think. Different Johnson. There's another Johnson in the authorities binder. Is there? No. I mean, the rationality, certainly the rationality argument is now put in oral submissions. I heard reference to Tameside, and the fact that, or the suggestion that hepatitis B has never been the subject of consideration. The argument seems to have moved on. It's a new argument, but I'm happy to deal with it. Again, the point is that one has to understand the nature of the decision that was taken to set up the scheme, which was there was a group of people suffering from hepatitis C that the Secretary of State decided there was a lot of pressure for them to receive some form of additional payment, and the Secretary of State decided to make it to them. He drew a boundary around that scheme at the point of screening. Hepatitis B victims are one concentric circle further away from the group of people that the scheme was established to target. And so when the Secretary of State decided to draw the line around screening, and inherently that's where the consideration ends. It can't be irrational in my submission. There can't be any kind of Tameside challenge to say, well, you didn't also look at hepatitis B. That may or may not be right, but not every decision to do one thing should be treated in public law terms as a decision not to do everything else, because otherwise everyone can come along and say, well, it's irrational that you didn't consider my situation or my situation or my situation. Now, delay.
Well, if you're right about Article 14, then you're probably right about irrationality.
Yes, I think they're pretty much the same arguments. Delay. this is really the delve issue. So I think that was tab 13 of the authority fund. And it's page 208. And in particular, paragraph 124 onwards. Now the question often arises.
So which page is 100?
Page 270 in the hard copy.
$117.
270.
Sorry.
Yeah,
Two,
no.
270. It's paragraph 124.
124.
Unlawful legislation is not a continuing unlawful act in the sense that the time limit for challenging it by way of judicial review rolls forward for as long as the legislation continues to apply. If that were the test, there would effectively be no time limit. For challenging primary or secondary legislation, or for that matter, administrative conduct which continues to affect a claimant, or until the action is withdrawn or revised. And my Lord Justice Dingemans made the point during my learned friend submissions that the challenge is to the continuing payment of ex gratia payments, and really these cases can often be analysed in two different ways. Is it a continuing decision to maintain a ex gratia scheme, or is it a one-off decision to establish an ex gratia scheme and everything else follows from that? In my submission, this is the latter type. There was a decision in 2003 and then again in 2017 to establish and maintain a scheme. It is an administrative act. It continues to affect the claimant. It has affected him since its inception. So at any point since 2003, he could have brought this claim. He says he didn't bring it earlier, I think, because it was only at the IBI when it became apparent that he wasn't the only one. So there might be a basis for challenging the boundary. But there needn't have been others in order for him to be able to challenge a boundary, not least because his own submission is the fewer people there are outside the scheme, the harder it is to justify the discrimination. He has always known that, as he says, as he puts it, that he has a disease which is similar to hepatitis C, and that, as he puts it, there's no rational basis for distinguishing between the two. So he has always been able to bring that claim. So this is not a case of, in my submission, of continuing conduct. So the distinction is drawn in Delve with the case of O'Connor in the Bar Standards Court, where a barrister was subject to a number of continuing acts of unlawfulness, and that was all grouped together and viewed as one long continuing act, and time would only start to run from the end of the act. Now there's nothing similar here in this case, which can be viewed as a number of continuing decisions or acts which can be joined together as a continuing obligation.
But can I just put this question to you? Suppose in the infected blood inquiry, Mr. Justice Langstaff says, well, actually, I can't see a fair basis for excluding the hepatitis B. The Minister will then have to consider that and then will then come to a decision. So that would restart the clock when he considers Mr. Justice Langstaff's recommendation.
Yes.
But you say at the moment there's no clock running.
Yes. And we also say that because of this ministerial submission, the clock has restarted in respect of
Time limit.
the cut-off date.
Yeah.
Yes.
But he's not a cut-off date person.
He's not a cut-off date person.
So why isn't paragraph 28 of Johnson, which really is Johnson in 2016, 2017 actually, hearing. Why is that not relevant? That is the the illegitimate child who's deprived of citizenship.
It's not a scheme.
No, it's not a scheme, but it's a continuing situation that the child is deprived of citizenship in the same way as it's a continuing situation that this person doesn't get compensation.
It affected him once he'd committed the manslaughter and then was going to be deported, because then his status mattered, and if there had been a lawful operation of status, he would have always had citizenship rather than the impermissible discrimination. One of these ones was very difficult to sort of work out some of the right lines.
Well, I mean, it's very difficult to me because in this case, he could have been, for example, extremely wealthy and then lost all his money for completely different reasons and not cared whether he got compensation. And then all of a sudden he's on his uppers and needs compensation and says, well, exactly the same as the illegitimate status. He says, I didn't care whether I had citizenship before, but now I do in exactly the same way here.
Well,
I mean, I can see what you say about Delve, but I can also see what Mr. Howells says about Johnson. What do you say about Johnson?
Well, in your wealthy man who loses his money case, the court has a discretion to grant an extension of time in such circumstances. But nothing's like that is said here, where the claimant's always been in the same situation, the appellant's always been in the same situation, always known since 2004 that he potentially had a claim. So the discretion to extend time would be subject to different considerations. I agree that these cases are hard to reconcile. Delve refers explicitly to the establishment of schemes under primary secondary legislation or as a result of administrative acts, and says that the date that time starts to run is the date that the scheme first applies to you, or you're first disadvantaged by the criteria of the scheme, as this individual always has been. Nothing's changed since 2003.
I suppose it would be possible to reconcile Johnson with that by saying he only became disadvantaged when he became subject to automatic deportation provisions.
There's a hint of that at any point his status could come and bite him, as it were. And on the question of extension of time, I've made the point that nothing has changed. If you're with me on being out of time, on the question of extension of time, there's nothing has changed since 2003. There's no error identified in the decision of Spencer J. Sorry, not Spencer J. Her name escapes me.
Mrs. Justice Stacey.
Mrs. Justice Stacey. And I've articulated the reasons in my written submissions as to why time shouldn't be extended. And then finally, the question of how we got here, if I may. And
how does that matter?
How does it matter?
I mean, if you were wrong in everything you'd said thus far, how does it matter?
I'm sure you would make the same difference either way.
So it's a purely forensic point.
It's a purely, yes.
Or it might be said purely a jury point.
But we're not a jury. There's only three of us. Well, I mean, I'm not stopping you. I think I know the point.
Look, I've spelled it out in the skeleton argument.
Yeah.
And we sense your frustration.
Yes, it has been. This case, unfortunately, has followed a pattern of things coming up at the last minute without any real context or explanation. This was the worst example of it. We say, had we just been asked at the time, we could have provided an explanation, and we might never have been here. The basis on which Lord Justice Holyrood granted permission, he is only giving reasons which relate to this apparent discrepancy.
No, I understand, but then there might be an injustice perpetrated if you're wrong about everything, and which is why it's so such a waste of time hearing submissions about it, because if you're right, you're right, and if you're wrong, you're wrong.
Well, look, it does worry us. It is frustrating, and as I say, I made the point that we say the claimant ought to have known because this has always been
I get that.
public record.
Well, but it wasn't. No suggestion it was done deliberately.
Well, I did raise the suggestion that on the face of it, on the basis of the explanations that have been provided to us in party-party correspondence, they did also know that this was not a subject of any real doubt.
Well, you can't make an allegation that it's deliberate attempt to mislead the court on that basis, Mr.
No, I
Tanker.
mean we've asked the questions. What did you know and when? We were told that Mr. Howells would deal with it in oral submissions, and he hasn't.
He hasn't yet. I suspect he's standing up because I think he wants to.
No, and I'm careful to say that this is on the face of it because I don't want to make unfounded allegations. But I do want to raise it.
But you know, the problem with all this is that, as I say, if it's a good case and it was bounced out for the wrong reasons, that's quite important to this court. That's what we're here for. And if there's been some bad practice along the way, then that's a matter perhaps for professional authorities or anything else. But it doesn't affect the fact that if this claimant has a proper claim, which should be given permission, then this claimant should get permission. Yeah. And you know, that's why I'm slightly unwilling to hear a lot about it. Well, let's just hear what Mr. Howells wants to say, so you can respond to it.
Well, there's one point. I don't blame my learned friend for not understanding how disclosure works in the inquiry. There are millions of documents on an online platform that would take me a lifetime to read. My learned friend is assuming that because a document was disclosed by the inquiry on this online platform that we knew about it. That's the mistake. We didn't know about the 1973 minutes until it was brought specifically to our attention by Dr. Rejman in his witness statement. I then found it, and on that basis I accept that by December 1972, as a matter of fact, all regional transfusion centres had implemented this test. But until that point, it wasn't clear. It had been introduced, but it wasn't clear that as a matter of fact, it was implemented across the board. My learned friend's submission before Lord Justice Holroyd was that it had been implemented widely, and that's what set the hairs running, frankly, both in Lord Justice Holroyd's mind and ours. And so that's how it's arisen. We didn't know this. The documents were there, but so were millions of others. And so
You didn't
that's
know
how it's
it,
come
you
about.
could have known it.
Well, it's subject to the fact that if you'd have put in a bill for reading every single document on the website, I doubt the Secretary of State would have been very thrilled with that, or indeed authorised it.
But I can assure you, Sir Brian Langstaff would not authorize.
All right. Well, Mr. Tangle, there it is.
My lord, I was frustrated. We've been frustrated for
You
many
can go
months.
outside and stamp your foot.
But no, I absolutely accept the points your lordship has made, and I'm not suggesting for a moment that even if our suspicions were well founded, that Mr. Howell's lay client should suffer as a result of that. So no, of course you will grant permission if you think permission should be granted and not.
Yes, we will. You may be assured of that, and if we don't think it should be granted, we won't grant it.
And I would never expect otherwise from any judge, let alone a powerful constitution such as this. My lord, lady, you've got my permissions. Ultimately, it's a straightforward case. Well, at least at the permissions.
Straightforward-ish.
Straightforward-ish. But it's a balancing exercise ultimately between how similar is this appellant to those who do benefit from the scheme against the ability of the Secretary of State to draw a bright line in the particular circumstances of this scheme.
You know, the two most confusing things about judicial review are the words balancing exercise and proportionality exercise.
Did I use them both just now?
No, you didn't.
Not in the same sentence.
But I think I understand what we have to do. But Mr. Tankle, your submissions have been very helpful. Thank you. Mr. Howes.
Lord, may I pick up where my little friend ultimately left off in relation to time, just to make one point. And that is, if the court considers the reason given by Mr. Justice Mostyn at page 113 of the supplementary bundle, the paragraph 2, he said that although it could be argued that the claimant is years out of time, I take the view that the correct date when the clock started was the 17th of June 2020 when her claim was refused. What happened in Chalice was an application was made which was bound to be refused. Whereas what's happened in this case is a request was made for a change in the boundaries rather than make an application that was bound to be refused. So it's kind of the same point. And so what could have happened in this case is we could have made an application that would be bound to fail, and then the continue in act point that happened, that my Lord Dingemans raised about it only bit when he committed a criminal offence, is about to be deported. Well, I could submit that it would have bitten then if he'd made an application that was bound to fail. There was no point in doing that, of course. The second point upon which I'd like to reply is just to draw the court's attention to the scale of the problem of hepatitis B infection, because I know that the numbers, as Lordship, the Master of the Rolls, has identified, don't stack up. There might be a number of reasons for that. Natural clearance may be one. And I don't intend to take you through all the Penrose references. They're in my suggested reading, all the references, and it wouldn't be fruitful to go through them now. But there is one reference I'd like to draw the court's attention to, and it's on page 1 of the supplementary bundle. Page 1.
Oh.
And it's the report of Dr. Gunson, who was the chair of the National Blood Transfusion Service.
Sorry, when I read it last time, I wondered, whose was the highlighting? This was just on the
Well,
document.
that's relativity, so that's the online platform. So this is, when I read a document, I highlight it. But of course, my solicitor accesses the same document and can't get the...
Oh, right. I just wondered whether it was anyone original, so it was just yours.
This is my highlighting.
Right, okay, no worries. Thank you.
The inquiry.
So this is page 1 of tab 1.
My lady, yes. And it's the first box of highlighting.
The incident of hepatitis has changed little.
Yes. And that's rather the pooling to make blood products point, is that even though screening's been introduced, it was still a major problem in the mid-80s.
Yes.
The third point is this statutory scheme point. May I deal with a suggestion made by Lordship Lord Dingemans that what in fact the Secretary of State was doing was exercising prerogative powers. In my submission, that's not a correct analysis. The powers are statutory powers that emanate from the National Health Service Act 2006. I appreciate that the court doesn't have the Act in front of it, but for example, one power is Section 2, which is general power. What it says is the Secretary of State, the board, or a clinical commissioning group may do anything which is calculated to facilitate or is conducive or incidental to the discharge of any function conferred on that person by this Act. And so the National Health Service Act and its predecessor acts replaced prerogative powers. And the court may be familiar, the name escapes me for the moment, in the immigration context. There's high authority that says, where an argument was run that immigration powers, control of immigration is a raw prerogative power.
No, once you've got statutes.
Once you've got a statute.
Prerogative is excluded, but I mean, they're as broadly expressed as prerogative powers, and it's simply updating them to put them in the NHS Act. Yeah.
Yes, so it's the power to make the directions comes from the NHS Act.
Yeah.
I can take the court to Benyon, it's at the back of the authorities bundle. Statutory legislation, including directions, has the force of primary legislation. So there's no point to be made about the fact that these are just directions. My Lord, would it help if I took it to Benyon in the relevant passages? It's in the authorities bundle. It's the last tab. So tab 16. And page 359. It's the latest edition. It's a fairly new edition. The first paragraph is paragraph 3.1. It's under the heading Nature, Type and Form of Delegated Legislation, Definition of Delegated Legislation. Then the editor says, delegated legislation is law made by a person or body under legislative powers conferred by Act. A valid provision of delegated legislation has the same force of law as an Act. That's the first point.
Yes, but there's no delegated legislation saying there shall be a scheme.
Well, the delegated legislation is the power to make delegated legislation by the Minister is Section 7 of the NHS Act, which gives the Secretary of State his powers in respect of health.
But the point that's made against you is that the Minister decided to institute an ex gratia scheme, you may say, either by exercise of his prerogative powers or by exercise of his ministerial powers under the NHS Act. But it was the exercise of the power that created the scheme, not legislation. It doesn't create a statutory right, that's the point.
Well, in my submission, my Lord, that's a distinction without a difference.
Really?
So, for example, if you think about...
Well, what if Parliament had legislated there shall be there shall be a scheme that benefits only HCV people, right? Then you'd be able to say, well, there is a statutory right to a scheme, and that is a discriminatory statute.
My Lord, had it been made in primary legislation, we wouldn't be here.
You wouldn't be here.
That's
But
the
if it's
point.
delegated legislation,
It's open to challenge.
is what's happening.
And so it's the point I made about the JT case, which is the criminal injuries compensation case. What the statute said was that the Secretary of State must establish a scheme, but the scheme was not set out in the statute. The duty to make the scheme was set out in the statute. That's the same here. So the Secretary of State, through delegated legislation, has put a duty on the...
But that's not the same, and that's the whole point. In the criminal injuries case, the duty, there was a duty to make a scheme to compensate criminals. There is no duty in the statute, just a duty to exercise powers as Minister of Health.
Accept that there's a difference.
So that's a big difference.
The difference is a duty in the Criminal Injuries Compensation Act to set up the scheme, whereas here it's a power. But nevertheless...
No, it's not. There's not even an express power. It's just he's the minister and he can do whatever he needs to make the health service good.
But establishing the scheme was a lawful exercise of the power that he had.
Yes.
But the point is that statutory powers were used to establish the scheme. So the scheme is on a statutory footing, and that's the point that is made by the Court of Appeal in JT. That it's not just an ex gratia scheme using prerogative powers, but it is on a statutory footing. So in my submission, it doesn't matter the point that your Lordship identified, that there's a duty in an act, but here it was just an exercise of powers to make delegated legislation. My submission is beside the point. Moreover...
But you accept that the scheme that he did set up was the ex gratia scheme?
Well, ex gratia means just that it's not linked to...
There was no duty to set one up. And that does go, I mean, subject to your point about disability, which I well understand, that does go to intensity of review. Because if there's a duty on a minister to set up a scheme, that is different from the minister waking up one morning and thinking, oh, I might set up a scheme.
As we saw in Crown on the application of RJN, an assertable right doesn't need to be a statutory right. Legitimate expectation is enough. So by establishing the scheme, the Secretary of State has created legitimate expectations. He's gone further than is required by Article 8 or by Article 1, Protocol 1. but the case law was clear, and I won't take the court to it again. You have the references. Where Secretary of State decides to go further and establish a scheme, then he must do so without discrimination. That's the point. That here a scheme has been established, and he must do so without discriminating. Now, Your Lordship, the Master of the Rolls, said, well, it's inevitable in any scheme that there will be discrimination. Decisions have to be made, but the point is whether the discrimination can be justified.
Well, I think you have to say without unlawful discrimination.
Absolutely.
Because, of course, you will discriminate against those who don't have the disease, for example.
Yes. And that's the point made by Lord Newberger, is can the scheme, as it's drawn, be justified? But I would also remind the court that it's not the scheme that the Secretary of State must justify. It's not, we set up a scheme for hepatitis C victims. That's a really good thing to do. It makes perfect sense. It's justified. It's the difference in treatment that has to be justified. So the Secretary of State must explain why those infected with hepatitis B were not included. It's not enough to say it's a good idea to include those with hepatitis C. Spectre of cost as a justification has been raised. Cost in and of itself is not good justification. What must be done if there are only finite resources is arrive at a scheme that is not discriminatory within the resources available. And for that, I rely on TD, paragraphs 85 to 86, page 228. Lord, unless I can assist further, those are my points in reply.
Thank you very much. Well, thank you both very much, and your solicitors as well. We'll take time to consider our judgments and hand them down in the usual way, and when we do, will you please agree any consequential orders and costs, and send us any typographical but not substantive corrections to the judgment. And that's all I can think of. I can't guarantee that you'll get these judgments before the 4th of February, I'm afraid. But I don't see any reason why, if permission is granted, it won't be possible, as you say, for us to say in the judgment they should be joined, and then they can be joined afterwards.
And for the case management hearing.
No. Very good. Okay, thank you.